Hi, guys. This is Andre, Horizon State News. And I was doing this, I guess you call it an audit of a traffic stop a couple days ago on January 13th, 2024. And my concern about this particular traffic stop was I'm not sure what type of documentation this driver received after the stop was concluded and the Horizon State Texas Police let this motorist leave. It seemed like this traffic stop was very brief, and this motorist, who was a woman, I'm not sure if she received either, a citation or a written warning. I've tried reading the Texas Code of Criminal Procedure over the past few years. There was a law that was passed in 2017 called the SANDRA Bland Act. I can go into more detail about that law in the future, but that's where this particular portion of the Texas Code of Criminal Procedure comes from. That's where it's codified, and so I'm not a lawyer, of course. So sometimes things appear to be confusing to me, and I'm not quite sure if these police officers, to this day, after always checking the Code of Criminal Procedure and trying to figure it out, to this day, I'm not quite sure if these Texas police agencies throughout the state are required to give a written warning or if they're allowed to just give a verbal warning. I found news articles from years in the past that said that written warnings are required. There's no more verbal warnings. But then right inside the Texas Code of Criminal Procedure, it does mention verbal warning. So I don't know what to make of it. Maybe if one of you guys happens to be a lawyer or a judge, you could put in the comment section below what's going on here. But anyway, I know that the Texas Code of Criminal Procedure, Article 2.133 and 2.134 deal with racial profiling stop data. And so that's where that's one of the reasons that this law exists, is that the state government wants all Texas police agencies to document all their stops. At least that's what I'm interpreting from it, is that they want all police agencies to document all their stops, including warnings. But, or at least that's what I thought. I thought that they're supposed to be including warnings, which means that all warnings even have to be written out. But maybe I'm wrong, but that's what I interpreted. Anyway, this particular stop, like I said, it happened very briefly. I don't think anything written was given to this lady. And if that's the case, and I'm correct, that she should have gotten a written warning according to Texas state law, which the Texas Code of Criminal Procedure, that's Texas state law, well then, I feel like the Horizon State Texas Police Department should be aware of that if they're not already. Especially after I had spoken to the chief himself back on December 19th, a few weeks ago, regarding the traffic stop with Sergeant Rosas with the 4 Hispanic men that were detained for what I consider to be a substantial amount of time, while Sergeant Rosas called the United States Border Patrol to have the 4 men, investigated and interrogated about their immigration status and whatever other, information that the Border Patrol might want, like criminal information and all that. Thank you, sir.
Oh, you got it. Take care.
And I know you're a busy man, but have you maybe had I'm sure you've heard about the November 2nd Sergeant Rosas interaction with the 4 men at the Murphy's Express near the Walmart? There's a traffic stop. There was, I believe it was lengthened more than is allowed by the 4th Amendment of the U.S. Constitution. I just want to make you aware of that.
Okay.
Is that Sergeant Rosas?
Do you remember the date?
Yes, sir. It's November 2nd.
November 2nd.
It was between 5:30 and 7:30 p.m. Officer Sierra, the tall one, and Officer Campbell came to back him up.
Okay.
Sergeant Rosas, he detained a motor vehicle which had 3 passengers and 1 driver, so 4 occupants. The stop was initially because of a broken stop lamp, so it was just like a brake light. And then once he did the initial stop, he then, I guess, I'm assuming, he stopped what he was doing regarding the normal traffic stop, and then he called the United States Border Patrol. Because that is, I have proof of that on video, is that the United States Border Patrol showed up with a paddy wagon and a patrol vehicle. So it wasn't just a regular Border Patrol patrol vehicle. It was, in addition, they brought a paddy wagon as if they were ready to detain or arrest these passengers and the driver.
Rodriguez v. United States, 2015. On March 27, 2012, a canine officer from Valley, Nebraska, pulled over a vehicle on the highway at 12:06 a.m. for veering onto the shoulder. The officer requested identification from both the driver, Dennis Rodriguez, and the passenger, Scott Pullman. After running a records check on both individuals, the officer returned to the vehicle to issue a warning. After the warning, the canine officer asked the driver if he could walk his dog around the vehicle. Rodriguez refused, and the canine officer asked both men to step out of the vehicle. While walking the dog around the vehicle, the dog indicated that there were drugs in the car. A search of the vehicle produced a large bag of methamphetamine. The search took 7 to 8 minutes. Rodriguez was indicted in federal court. He moved to suppress the evidence on the grounds that the officers had no reasonable suspicion to prolong the stop and conduct a dog sniff. The case went all the way to the U.S. Supreme Court. In a 5-4 decision, the Supreme Court ruled that the search was a violation of the Fourth Amendment. The court ruled that since the mission of the stop was completed with the issuance of a warning, it was unconstitutional to prolong the stop with a drug sniff. This made the dog sniff unrelated to the initial stop.
And again, just to explain the process, the way it works is the person, gets issued a citation on the side of the road, and it's on a device that looks like, well, it is a cell phone. It's like an Android, and they're department issued. So then, they get their citation, and then the officer will then hit a button which creates a sync, and then the court gets that paperwork or that data. So then from that data, it generates the actual affidavit, and then the officer is called in to sign it. You know what I mean?
Yes, but
so
the police officer...
Yeah, that's how the... I'm sorry?
I'm sorry. I hate to interrupt, but the police officer that issues the citation, which is a citation in lieu of custodial arrest, he is supposed to write a probable cause affidavit himself or herself.
You know what? I'm gonna, this is one of those things where, if you want to contest the validity of that, you should talk to the city lawyers or make, you know what I'm saying? Because the way it's worked since we've had ticket writers for about 10 years now, and, I'd be willing to, bet $1 that it's legit, is that, the device generates, a cookie cutter type of affidavit, and then the officer signs to it. You know what I mean? That's just how it works.
And here from Wikipedia, they point out that this was all back to 1761. It was the 1761 of Paxton v. Gray. And there they say, a group of outraged Boston businessmen, which included Ezekiel Goldthwait, engaged James Otis Jr. to challenge the legality of writs of assistance before the Superior Court. These writs enabled the authorities to enter any home with no advance notice, no probable cause, no reason given. Of course, no oath, no affirmation, none of that stuff that came out of it. James Otis Jr., of course, we can call him the founding father of the Fourth Amendment, even though he didn't live to see it ratified. Now, Otis considered himself, they say, a loyal subject to the crown, yet he argued against the writs of assistance in a nearly 5-hour oration before a select audience in the State House in February of 1761. Now, here is just a few of my favorite quotes from that speech. We're getting them from notes from John Adams, who, as a young man at the time, was there present and taking notes on the event. And here, right in the outset, Otis goes right to it. He says, "I will to my dying day oppose with all the powers and faculties God has given me all such instruments of slavery on the one hand and villainy on the other, as this writ of assistance is." I mean, this is not pulling any punches right out of the gates. He says, "It appears to me the worst instrument of arbitrary power." Now, arbitrary power, if you heard me talk about this, many of the founders and old revolutionaries use this phrase. They saw as a government without limits, a power without restraint, as Samuel Adams put it, is a tyranny. And arbitrary is power that can be changed on a whim. And he says, "It appears to me the worst instrument of arbitrary power, not just the bad, but the worst, the most destructive of English liberty and the fundamental principles of law that was ever found in an English law book." And if he makes the point that there's a big difference between a general warrant, an unending warrant, and something that has a special purpose, a specific purpose, something specially named. He says, "Your honors will find in the old books concerning the office of a justice of the peace precedents of general warrants to search suspected houses. But in more modern books, you will find only special warrants to search such and such houses specially named, in which the complainant has before sworn that he suspects his goods are concealed, and you will find it adjudged that special warrants only are legal." So any broad-based general warrant where they aren't naming exactly where they're going, what they're looking for, is something that they consider to be illegal. And James Otis certainly made the case about this.